Hello guys, welcome back to my channel Rahul Print Study. In this video, we just will overview on the topic rule of law. What is the concept behind this topic rule of law? What is the origin of rule of law? Meaning of rule of law. First of all, we have right to introduction of rule of law, meaning of rule of law, historical development of rule of law, and the Dicey's views on rule of law. And then after you can also overview the uh, implication in Indian democracy regarding rule of law, and then after you have just reached the conclusion of yours. So guys, before move ahead, please subscribe this channel and press the bell icon to get notification on time. You can also get this PDF from my Telegram channel Rahul Print Study, same as YouTube channel. So guys, let's start. Okay, the introduction of rule of law is like rule of law is the supreme manifestation of human civilization and the culture, and is a new lingua franca. It means of global moral thought. It's a type of language. It is an internal value of constitutionalism, and an inherent attribute of democracy and good governance. So, the concept of the rule of law is an animation of natural law and remains as a historical ideal which makes a powerful appeal even today to be ruled by law, not by powerful man. So it's a arbitrary upon the anarchy. It's talk about the accordingly rule of law. Rule of law is to understood neither as a rule nor a law. It is generally understood as a doctrine of state political morality, which concentrates on the rule of law is securing correct balance between rights and powers, what is wrong and what is right, between individuals and the state in any free and civil society. This balance may be drawn by law based on freedom, justice, equality, and accountability. Therefore, it infuses law with moral qualities. Thus, the rule of law is a law of rules or principles. What is the meaning of rule of law? The term rule of law is derived from French phrase le principe de l'égalité, means the principle of legality, which refers to a government based on principle of law and not of man. In this sense, the concept of la principe de l'égalité was opposed to arbitrary power. Okay, arbitrary power means which is not based on the rule, so it opposes the arbitrary power. What is the historical background of rule of law? Historical development of rule of law. Early Greeks located the concept of rule of law in right reason. Right reason means what is wrong, what is right. It must inform all state actions. Aristotle says made it difference between procedural justice and moral justice. Rule of law can be located in moral justice. Thomas Aquinas and St. Augustine located it in laws of God. Hobbes, Locke, Rousseau, this is the pioneer of natural justice, located in secular tradition of social contract. There is a concept, social contract, of Rousseau. The social contract theory developed the every individual sacrifice some rights to the particular authority to enjoy their rights time to time. The particular authority name knowingly as a state, in which a state is formed only to protect the life, liberty, and dignity of the individual. Dicey, the father of rule of law, located it in right-based liberalism and judicial review. Modern writers like Richard Fallon located it in quality of law, which includes clarity, efficacy, stability, authority, and impartial justice. Nevertheless, Edward Cake is said to be the originator of this concept when he asserted that king must be under God and law, and thus vindicated the supremacy of law over pretensions of the executive. James M. Buchanan distinguishes between law and rule of law. All primitive and non-democratic societies had law, but all liberal and progressive societies having rule of law are not necessarily lawless societies. Okay, now India historical development and at the time of ancient period, what is the implication of rule of law? In India, the concept of rule of law can be traced to under Upanishads, can be traced to the Upanishad. It provides law is the king of kings. Law is the kings of kings. It is more powerful and rigid than the king. There is nothing higher than law. Article 14 also says equality before law and equal protection of law. Every man and every individual is equal in the eyes of law. By its power, the weak shall prevail over the strong, and justice shall triumph. Thus, in monarchy, the concept of law developed to control the exercise of the arbitrary. So, it opposes the arbitrariness. Okay, the concept of law developed to control of the exercise of the arbitrary power of the monarchs who claimed divine power to rule. In a democracy country like India, the concept has assumed different dimensions and means that the holders of public powers must be able to justify publicly that the exercise of power is legally valid and socially just. Professor A.V. Dicey, the pioneer of the rule of law, later developed on this concept in the course of his lecture at the Oxford University. Dicey was an individualist at the end of the golden Victorian era of laissez-faire in England. He wrote about the concept of rule of law. That was the reason why Dicey's concept of rule of law completed the of sense of wide power in hands of government official. According to him, whenever there is a discretion, there is room of arbitrariness. The rule of law is a viable and dynamic concept. Like many other such concepts, is not capable of any exact definition. This, however, does not mean that there is no agreement on the basis of values which it represents. The term of rule of law is used in contradictions to rule of man and rule according to law. Even in most autocratic forms of government, there is some law according to which the powers of the government are exercised. But it does not mean that there is the rule of law. Therefore, rule of law means that the law rules which is based on the principle of freedom, equality, no discrimination, fraternity, accountability, and non-arbitrariness, and is certain, regular, and predictable, using the word law in sense of just and lacks both. In this sense, the rule of law is an ideal. It is a modern name for natural law. In history, man has always appealed to something higher than that which is own creation. In jurisprudence, Romans called it just naturale. Medievalists called it the God of law of God. Hobbes, Locke, and Rousseau called it social contract or natural law, and the modern man calls it rule of law, like the SC. Okay, judicial on rule of law. The basic concept of rule of law is not a well defined legal concept. The courts generally would not invalidate any positive law on the ground that it violates the contents of the rule of law. However, in ADM Jabalpur versus Sikant Sukla case, popularly known as habeas corpus case, this case is also for the entrance purpose is important because this case is known as habeas corpus case. Habeas corpus is term read provided by Supreme Court and High Court to issue against the particular individual's uh, rights if it's infringed, like individual rights, like fundamental rights. Article 32 of Indian Constitution granted for the protection of every individual fundamental right, that is the constitutional remedy of fundamental rights, and 226 of article of High Court, sorry, this article granted to the High Court to issue the writ against the particular arbitrariness of fundamental rights and others. Article 226 of Indian Constitution gives the right to the High Court, and Article 32 of Indian Constitution gives to the right to the Supreme Court for the issue the writ against the protection of individual if it's infringed. So, and at the attempt in this case was made to challenge the detention orders during the emergency on the ground that it violates the principle of rule of law as the obligation to act in accordance with the rule of law is a central feature of our constitutional system and is the basic feature of constitutional. Though the contention did not succeed, and some justices even went on to suggest that during an emergency, the emergency provisions themselves constitute the rule of law, yet if the reasoning of all the five opinions is closely read, it becomes clear that the contention was accepted no matter it did not reflect in the final order passed by the court. Therefore, despite the unfortunate order to effect that the doers of the court during an emergency are completely set for the detainers, it is gratifying to note that the concept of rule of law can be used as a legal concept. In the opinion of some of the judges consisting the majority in the Kesavanand Bharati versus State of Kerala, Kesavanand Bharati, the rule of law was considered as a aspect of doctrine of basic structure of the constitution, which even the plenary power of parliament cannot read to amend. In Indira Gandhi versus Raj Narayan, in which the Supreme Court invalidated Clause 4 of Article 329A inserted in the Constitution by the Constitution 19 39th Amendment Act 1975 to immunize the election despite to the office of the Prime Minister from any kind of judicial review. Khanna and the Chandrachud, Justice Chandrachud held that Article 329 capital A violated the concept of basic structure. Other justices, though, did not go this extent, but certainly held that the Article 329 capital A clause 4 offends the concept of rule of law. This is the some facts regarding rule of law. We can go through this, guys. Let's move ahead to the other fact of the rule of law. It is a basic principle that the rule of law, the exercise of the power by the executive or by any other, must be in accordance with law, and the power of judicial review as conferred by the Constitution of India with a view to ensure that the law is observed and there is compliance with the requirements of law on the part of executive and other authorities, and it is through the power of judicial review that the rule of law is maintained and every organ of a state is kept within the limits of law. So there are three principles of rule of law. Before move ahead on that point, let the some fact regarding rule of law is necessary to understand the mechanism of rule of law. Okay, the concept, the term rule of law can be used in two sense: formalistic sense and the ideological sense. If used in the formalistic sense, it refers to organized power as opposed to a rule by one man. If used in an ideological sense, it refers to the regulation of the relationship of the citizen and the government, and in this sense, it becomes a concept of varied interest and contents. Now come to the three principle of Dicey, which is gives to the better understanding of rule of law. Dicey concluded that there was no administrative law in England. So Dicey has given three principles for rule of law. The first principle of Dicey's rule of law is the recognized of a cardinal principle of democratic government as opposed to arbitrary and autocracy governments, which lays down that no functionary of the government should have wide arbitrary or discretionary power to interference with the liberty and freedom of the people. The second principle of Dicey is based on the equality. Also enunciates a democratic principle of equal subjection of law of all persons to the ordinary law of the land as the administered by the ordinary courts. The third principle of Dicey says, in fact, does not lay down any legal rule but merely explains one aspect of British constitutional system where the common law is the source of fundamental freedom of people. He thus distinguishes the British system from that of many other countries which had a written constitution. So Britain constitution has no written constitution. It differs from other constitution which is written constitution with a chapter on individual rights. That he feared that the source of fundamental rights of the people was any documents. The right could not be abrogated at any time by amending the constitution. This is what happened in India during the 1975 during emergency, when the Supreme Court ruled that the even illegal acts of the government could not be challenged in the court, and because it was found that which had been suspended by the presidential proclamation and not any common law of the people. So this is the three principle about the rule of law given by Dicey. In next video we'll cover the criticism of rule of law given by Dicey. Some jurist has criticized the rule of law of Dicey. We'll cover in next video. That's it for now, guys. I will explain the criticism and the view of rule of law of Dicey in next video. So by that video you can write your answer about concept of rule of law of Dicey and their criticism and conclusion also. So thank you so much for watching this video. I hope this video will help you to be understanding the basic meaning and the feature of rule of law and the Indian context, what is the implication of rule of law. So guys, thank you so much again. Bye bye, take care, have a nice day.